deal in the matter of Save Stonehenge World Heritage Site Limited and the Secretary of State for Transport and others.
Mr. Wolfe. Good morning, my lords. As you'll have seen, Ms Stephanie David, Ms Victoria Hutton and I appear on behalf of the appellant in this matter. Ms Rose Grogan and Mr Nigel Fleming appear for the first respondent, the defendant to the judicial review, Mr Taylor for National Highways, Mr Harwood for Historic England.
Yes, thank you very much. Just before we get started properly, could I mention timetable? And in particular today, this afternoon, as some of you will be aware, the new Lord Chancellor and other law officers are being sworn, and that whole ceremony and procedure starts at 4:45. In the meantime, at least one member of this constitution needs to get into rather more ceremonial robes. So I'm afraid we'd like to stop today at 4 o'clock and make up that quarter of an hour tomorrow morning at 10:15 if that's convenient to everybody. I'm sorry about that, but it's going to make life a lot easier if we do that today. Otherwise, the timetable is as indicated in the email sent last week, which I assume you've all seen and digested.
My lord, yes. Can I just pick not so much the timetable up, but the structure of our submissions?
Of course, yes.
You will have seen, of course, that this is a rolled-up permission hearing, rolled up with appeal and permission hearing pursuant to Mr Lord Justice Lewison's permission, and therefore we are dealing with both the judgment and the decision below. That all comes from a decision of Mr Justice Holgate, of course, in February of this year, which in turn, in a slightly complicated way, was picking up an N461, a statement of claim with statements of facts and grounds, to which there had been an addition because there'd been some disclosure of documents after the commencement of the claim. Yes. So that's the sort of landscape of the materials. Yes. You have an appeal and you have a judicial review, which is slightly in two pieces.
Of course. And what it would help us most, I think, for you to do as you introduce these grounds to us, is at the outset of your submissions on each ground of appeal, if you could just tell us which ground in the claim it relates to, so that we can collect our own note properly on that.
Well, Lord, I certainly will do that. I hope the intention was that was at least introduced by the table that you have in paragraph 4 of our skeleton, which I hope is something of a route map to exactly the point my Lord's just raised with me.
Yes, so fine. Well, if you could, as you come to each ground, if you could just confirm that would really help.
Of course, of course.
But yes, thank you for that.
Well, Lord, in terms of the way we propose to deal with that, Ms Hutton dealt below with some of the World Heritage Convention points. She's going to deal with all the World Heritage Convention points in this court.
Right.
So that means she will deal with appeal grounds 5 and 6.
Yes.
And therefore, within that, JR grounds 3 and 4.
Yeah.
So that means I will be all morning and some of the afternoon dealing with the other grounds of appeal and judicial review. She will start sometime during the afternoon and carry on tomorrow morning.
Okay. Thank you.
I hope that assists.
Yes, very much so.
My lords, in terms of the submissions, can I start, if I may, with just a reminder? I know it's a reminder of some of the provisions of the Planning Act, because we, on our side, emphasise the particular statutory context of the matters before the court.
Yeah. And you can assume that we have familiarised ourselves, I should say once again, with the provisions of the Planning Act, because they are familiar to
I'm sure they are.
us.
I'm going to be very focused, I hope, and you'll tell me if I'm not being sufficiently focused. My Lord, all of these materials that were covered to some extent by the judge in his judgment. He summarised the provisions of the Planning Act, and he, as others have done, including my Lord, in other judgments, emphasised the way in which the development control regime that was introduced by the Planning Act was intended to some extent, streamline the process of dealing with nationally significant infrastructure projects.
Yeah.
And it did that in overall 2 ways. One of which was to introduce the concept of national policy statements.
Yes.
Of course, that's part of the context here. We have national policy statement in play. and secondly through the examination process, which is different to the traditional process of a planning inquiry. And both of those factors are relevant here.
Yes.
And we emphasise the nature of that process. And what we would emphasise is that whilst this is a streamlined and focused process, it still nonetheless has some core components. And we say, when I come to the process that should have taken place here, some key components implied into it when it comes to the procedure following a quashing. My Lord, within the Planning Act, I'm going to come back, if I may, to the provisions that you have in your bundle dealing with national policy statements and the review of those. That's section 6 and thereabouts. And I'm going to come back in due course, to the extent that I need to part 6, which deals with the examination process.
Yeah.
I just want to pick up, if I may, on 2 provisions, section 103
Yes.
and section 104, because they are the nub of the decision on a development consent order. Section 103(1), perhaps to emphasise the obvious, the Secretary of State has the function of deciding an application.
Could you be very kind, because I'm using electronic.
Oh, I apologise, my Lord.
But if you could give the bundle number, everything.
Would you like page number or a tab number?
I can probably cope with either, but page number is probably.
661.
Thank you so much. Yep, works perfectly.
My Lord, section 103, the Secretary of State has the function of deciding an application for an order granting development consent. We emphasise that because although in this particular instance that function had been, of course, permissibly delegated to a minister, it is the minister then who has the function. And we emphasise the minister, not therefore his or her officials.
Sorry, I mean, as a matter of principle, it could be an official. It wasn't on this occasion, but the fact that the power is vested in the Secretary of State doesn't exclude the Cartona principle. That always applies.
No. And that my Lord's obviously got the follow-up point, which wasn't the position here, but we don't make a point about what could be done in other instances, but absolutely right. And then section 104, which is on page 63.
Yeah.
104.1. This section applies in relation to an application for order granting development consent if a national policy statement has effect in relation to development of the description to which the application relates. And this is one such case because the national policy statement on national networks meaning strategic rail and strategic road, was in play. And then we have 2 mandatory provisions. Section 104.2, which sets out mandatory material considerations. 104.2, in deciding the application, the Secretary of State must have regard to, and the first item, little a, any national policy statement. Various others in AA through C, with which we're not directly concerned. And then in 104.2d, any other matters which the Secretary of State thinks are both important and relevant to the Secretary of State's decision. Now, that would appear to be the route through which the examining authority's report becomes relevant, because there's no, perhaps oddly, there's no express requirement to take into account the examining authority's report, even though, as a matter of statutory construction, it's a report to the Secretary of State. But that provision is plainly capable of going beyond that. You have, perhaps if I can just turn it up very briefly, in tab 44 of the appeal bundle, it's page 1807, sorry, authorities bundle, a decision in a case called Pierce, which at 1813, 1813, para 11, the judge made this observation on section 104.2d. Section 104.2d allows the Secretary of State to exercise a judgment on whether he should take into account any matters which are relevant but not mandatory material considerations. Now, I would say the word allows is not quite capturing it. We would say it's a requirement because the Secretary of State must have regard to those things which they think are both important and relevant. We say that mandates an evaluation as to what might be both important and relevant. And that therefore mandates an evaluation on what additional elements, evidence or submissions or whatever it may be, can be taken into account pursuant to the statutory provision, going beyond those things which in other circumstances might be said to be obviously material.
Yes, but the Secretary of State has a judgment to exercise, I think is really the force of that, isn't it?
Exactly right.
Yeah.
Exactly right. And then we come in due course to the base on which they need to exercise it. But that's right, my Lord, absolutely. So a judgment has to be made. Similarly, 104.3, now going beyond mandatory considerations to tell the Secretary of State how to decide the application.
Are we putting Pierce away now?
I can put that one away, I'm sorry, yes, should have said that. Must decide the application, this is 104.3 on page 63.
Yeah.
In accordance with any national policy statement, so obviously a national policy statement will include what you might call planning tests, except to the extent that one or more of the subsections 4 to 8 applies. So the starting presumption is decided in accordance with, but then you can depart from that, or you must depart from that in other circumstances, depending upon the nature of the provision within which we then fall. And just as a general observation, these are each 4 to 7 in particular, 4 to 8 in particular, are all cases where the triggering condition is one which is pointing against the grant of development consent. We don't say those things necessarily require refusal of development consent. The statutory structure is carefully nuanced, decide in accordance with the national policy statement unless, but each of the elements, and I'll come to them in a second, is something which, if it was triggered, is likely to be mitigating against the grant of development consent. Just taking those in turn, because several of them are in play here.
Does it do more than remove the obligation to decide the application?
No, it doesn't. It doesn't, my lord. It doesn't. It doesn't. It displaces the presumption, but we simply make the observation, forensically, if you like, that each of those conditions is something which is likely to be going against development consent. It doesn't mean, let me be clear, just take them one at a time. 104.4, this subsection applies if the Secretary of State is satisfied that deciding the application in accordance with any relevant national policy statement would lead the United Kingdom to being in breach of any of its international obligations. That does not, to answer my Lord's question, mean that the Secretary of State couldn't say, I realise this would put the UK in breach of some international obligation, I'm going to grant development consent nonetheless. But, and this is the important point for 104.4, that does require the Secretary of State, or the Minister in this case, to address his mind on a properly informed basis to the question of whether granting development consent in accordance with the national policy statement would lead the UK to be in breach of its international obligations. It's a mandatory evaluation on the way. Even if at the end of the day you say, this is going to put us in breach of international law, there are reasons to do it nonetheless. And 104.4 is in play here in relation to our arguments on the World Heritage Convention and Appeal Ground 7, JR Ground 6, in relation to the Paris Agreement when it comes to the National Policy Statement and greenhouse gas impact assessments. In each case, we say, Minister needed, on a properly informed basis, to address his mind to the international law position. Where that would have taken him is not a matter for our submissions, or indeed we say for the court. 104.5 and 6 sit together. 104.5, each of these follows broadly the same structure, requires a consideration of whether granting development, proceeding in accordance with the national policy statement, I should say, would place UK in breach of any duty imposed on the Secretary of State by any enactment. 104.6, whether doing so would be unlawful by virtue of any enactment. So again, at least in theory, the Secretary of State could say, well, granting this development consent would be unlawful for some other reason or put me in breach of some duty, but I'm going to do it anyway. And then 1047, this subsection applies if the Secretary of State is satisfied that the adverse impact of a proposed development would outweigh its benefits. And it may well be, again, point I made before in relation to how the examining authority's report fits in, that much of what the examining authority reports on to the Secretary of State comes into play through that provision, because much of what they report on is going to be adverse impacts and benefits. And we say those are all carefully calibrated. They imply, as I've indicated, as I've gone through, particular evaluations by the decision-making Secretary of State, Minister, or potentially officials.
Yeah.
If I could put that bundle down, if I may, and go to the core bundle. Within the core bundle, you have at page 153 a chronology. And I, again, by way of my introductory scene setting, simply want to identify to the court what we say are the key elements of the overall process with which we're concerned.
Yeah.
On page 153, we see that the DCO application in the present case was made in 2018, and then following the dates down, 2nd of April 2019 was the start of the examination, and you have a little bit of detail of the dates of that process and of the complexity of that process. That ran from April of 2019 to October of 2019, we see over the page. That led to a report of the 2nd of January from the examining authority, extracts of which are in this court's bundle, in turn to the grant of development consent in November 2020, subject to, as we see, first judicial review, leading to 30th of July 2021, decision of Mr Justice Holgate quashing that first grant of development consent. On two grounds, and I'll come in a while, certainly on the question of alternatives, to explain to the court in a little bit more detail the precise basis of that quashing, because it's important for the process here. Quashed on two grounds, one relating to the Secretary of State's, as it was then, failure properly to consider the heritage impact on individual assets of the proposed scheme, and secondly, a failure to consider and reach a conclusion on the merits of alternatives. And that second point is particularly subtle and needs a bit of unpacking in due course. That then led, you see on page 155, to the redetermination process.
Yes.
Which essentially operates without the benefit of a statutory framework to guide it. There are no specific provisions in the Act dealing with the redetermination process. I see my Lord's puzzled face.
Well, you said statutory, and that would include Rule 20, but you've then qualified it to say there's nothing in the Act.
We'll come to Rule 20 in a bit. Rule 20 provides for the process which kicks off that process. The first entry here, 30th of November 2021, statement of matters. That's the bit that Rule 20 informs. And it kicks off the redetermination process. But beyond that, there's nothing in primary or secondary legislation which determines the process for a redetermination.
Well, Rule 20 does more than kick off matters. I mean, what it says is they must state what matters they're going to have the opportunity to make written representation. So it does deal both with the additional matters and the opportunity to make written representation.
Absolutely, I'll come to that in a bit. I'll come back to it, my Lord. I'm not ducking it. And I'll come to the redetermination process in a little bit more detail in a few minutes, if I may. That redetermination process, the toing and froing, multiple rounds of correspondence and so on, led in due course 24th of May, it's on page 156, to a ministerial submission to the Minister, which in due course led to a ministerial decision to approve the granting of the DCO. And again, I'll come in a moment to a little bit of detail on exactly that ministerial process. So we here are fundamentally concerned with the nature of the redetermination process and the basis on which the Minister then came to make his decision in the light of that redetermination process. Perhaps unnecessary to emphasise, therefore, that when the Minister came to make his decision on the redetermination process, there had not been a further examination by examining authority of the materials received during that redetermination process,
It's right to refer to it as a further examination, is it, as opposed to a reopening?
I'm not going to dance on that particular...
No, I mean, I don't know whether it's significant or not.
I'm not sure whether technically it would have been a reopening or would have been a fresh one, but my Lord's right. It would have been a process of the kind of an examination, but because it's not within the statutory framework, it wouldn't have been formally an examination.
I see, yes.
It wouldn't have been a statutory examination under the...
In a process which had the, if you like, the hallmarks of an examination, but wouldn't actually have been an examination.
Yes.
Yes, but you will need to explain whether that means the 4 people, or whatever number it was, are reconstituted in the same panel, or whether you appoint new panels and so on. You will need to fit into what you say should happen, or should have happened, with either the statutory provisions in the Act or the rules in the subordinate legislation. So if you're saying there's got to be a process, you need us to see where the virus for that process comes from.
I don't think there's any dispute that there is virus for that process.
Well, that's my word, but I mean, take us to the provisions at a suitable stage in your submissions that would show us how this would work, which people would do it in accordance with what provision and procedure.
Well, the simple answer to my Lord's point, and I can make the point now, is that there is no express statutory provision in the Act dealing with this process, because it's a situation which the Act doesn't provide for. Obviously, the Act provides for a statutory judicial review of a development consent order, but it's silent as to what happens after that, subject only to Rule 20. I mean, as it happens, we've seen we query the virus for Rule 20, but that's not an issue we need to decide. Rule 20 doesn't determine what happens following that initial statement of matters in terms of who is involved and in what way. And I don't think there's any dispute within the court, certainly there's no dispute in the decision letter, that the Secretary of State had the power to initiate a process. And again, perhaps to answer my Lord's question at least partly, what we focus on is not, as it were, the names of the people involved or how many of them there would have been, but on the nature of that process.
And
Yes,
is the key to it all fairness?
The key to it all is fairness, and I'll show you in due course that, again, in the same decision we saw before Pierce, there's a recognition that the rules are not exhaustive and the court can and does in certain circumstances has to imply in processes, and yes, the key is fairness, absolutely.
But there are provisions for the appointment of a single examiner or 4 examiners and so on. So one will need to know a little bit more than fairness to us all.
Well, you have in the bundle, and I come to it in due course, an example of a situation, a case where the Secretary of State appointed an expert assessor on aviation matters that happens, and whatever the power was in play there, we would say the same basis here. And the crucial thing which we do focus on here, to go back to my Lord's question, is fairness in the process, and we say the essential element of that is an inquisitorial process conducted by a person or persons with appropriate expertise. And that's the essential, boiled down to its minimum characteristic. And just to signpost where we're going, we say that's partly where the judge went wrong, because the judge focused on the question of whether it was necessary to have a process which allowed for oral hearings, issue-specific hearings, ISHs. And that was never the claimant's, the appellant's case. The claimant, the appellant, has never argued that there needed to be oral hearings as such. And indeed, that's not a necessary component of the examining authority process in the ordinary course of events first time round. There is a power to have oral hearings and a process around them if they happen, but they're not required. It can be an entirely written process. So we don't argue, have never argued that that was the crux. Picking up then, I may, what happened in the redetermination process.
Yes.
Picking it up, I'm not sure if you want my skeleton references on the way, skeleton paragraph 11 and following. We have a helpful explanation from Mr Gilmore, civil servant who oversaw this process, and that's in supplementary bundle 3. Page 157. And within his witness statement, I draw the court's attention in particular to paragraphs 8 through 11 and paragraphs 22 through 26. Let me just touch on those.
Did you say 8 to 11?
8 to 11 and 22 to 26.
Thank you.
8 to 11 speak to the general situation, 22 to 26 speak to the specific case here. Within 8 to 11, paragraph 9, and we don't disagree with the characterisation, says this: officials from within the Transport Infrastructure Planning Unit, in discussion with colleagues from Government Legal Department, consider the judgment, post a quashing, and will then draft a statement of matters which sets out those issues on which the Secretary of State regards as relevant for the redetermination of the application, and which he considers the applicant and interested parties may wish to provide more information on. And that's entirely right. So they officials, in practice, operate the process of framing the statement of matters. Depending on the nature of the issues, the applicant may be requested to provide additional information. In the first instance, then interested parties will be offered the opportunity to comment on that information and provide their own additional information. There may be several rounds of consultation if officials on behalf of the Secretary of State consider that further information is required to clarify responses and to ensure that all parties are given the opportunity to comment on additional information. So, characterises it, we say correctly, as in the nature of a consultation, and we see that word is used in the contemporaneous documents at the time, and explains, and again, consistent with what happened here, that what the process which is adopted is of clarifying responses and giving parties an opportunity to comment on additional information. Just to touch on that language, and it reflects what happened here in practice, that is not describing an inquisitorial process of questions being asked to test the evidence in the way that an examining authority would, and I'll show you that in due course. It is information gathering, and you'll see that language, versions of it being used again in the contemporaneous documents in a moment. Para 10, officials will read representations as they are received, including ad hoc representations made outside of formal consultation exercises, and consider whether they contain matters which are material to the Secretary of State's decision, whether further clarification is required, and so on. And that's the process of officials...
And whether people should be given the opportunity to comment on them.
And whether people get the opportunity to comment on it, exactly. We don't complain, just to be clear, we don't complain that we or anybody else didn't have the opportunity to comment on the information that was being provided.
So to that extent, you accept that you're entitled to challenge.
Well, we were entitled to challenge, as in put in a contrary position. What was missing, and this is the two bits of the claim, is what the recipient of that information did, because if this had been information going to an examining authority, they would have been operating an inquisitorial process, testing the evidence, examining the evidence, to use the statutory word, and then to report to the Secretary of State on it. That's part of the complaint. Second part of the complaint is to what extent was that information then passed to the minister who needed to know it for the purpose of his decision.
In the written examination process, during the re-examination, is that similar or dissimilar? Do people comment on submissions that have been made by the various interested parties?
Sorry, I misunderstood the question. In the statutory examination process.
The original examination process, which is written subject to hearing all specific issues, is it a similar position? People write in, setting out their statements and comment on each other's statements?
Exactly
or
right.
does the examiners write back and say, no, we don't agree with anything you've said, we'd like you to...
It's both. It's both. The examining authority initiates questions by way of, to use the language, interrogating, probing, would be another word, what's received by them. We've got examples of that in the bundle of the kinds of interrogation that examining authorities undertake. It's not simply a process of you say this, they say that, you say that, in the way of a dialogue between third parties. The examining authority has a proactive role, and I'll show you in due course the guidance that informs that process. Paragraph 11. When officials consider they have all the information they need, they'll begin to draft a decision letter. This work is led by a case manager or case managers assigned to the application. They may start work on the section of the decision letter before the end of the consultation if matters in those sections are not the subject of ongoing consultation. The draft decision letter will include all those matters which officials in consultation with lawyers assigned to the cases consider are relevant to the material to the decision which the Minister may make on behalf of the Secretary of State. Absolutely sure that's what happens. The potential difficulty with that, and it's what happened here, is if they don't provide the Secretary of State with the information required for him to make the decision. And that could arise in a number of ways. Firstly, because this is, and we'll show you this in due course, in the nature of a consultation, so consultation responses.
We need to be careful. Although they use the word consultation, they're using it as a shorthand to reflect the Rule 20 process. They're not using it in the sense of a Moseley consultation, are they?
Well, you will see in a second how they describe it in the correspondence, but we say the same principles end up applying.
So you say that everything that's sent in must go to the Secretary of State for him to read then? Otherwise you can't conscientiously consider.
No, in the same way as it's perfectly permissible to have a consultation in the classic Moseley sense, but it's well established, obviously, that the consultor in a pure Moseley case doesn't need to read every consultation response. But what they do need to have is a proper summary of responses, including where people are making points which are good, bad or indifferent, for them to evaluate the strength of the points which inform their decision. We say the same principle applies here. And I'll show you now, I'm very nearly getting to it, where in the documentation, in effect, that's what they say is going to happen. So paragraph 11, just to make the further point I was going to make there, We are here, just to remind the court, in the context of section 104(2)(d), where the minister has to address his mind to what points are relevant and important, that's the statutory language, for him to take into account. And that recognises that the minister might look at a point and say, well, I don't think that's relevant or important.
Which points has he got to look at?
I'm sorry, my lord?
Which points has he got to look at?
Well, we would say here, we'll show you some examples, we would show you some examples, but it's not in the nature of reducing the exercise to the irreducible minimum legally necessary, sometimes the word obviously material is used, points that are essential for the decision in a classic sense. That's why this is a different situation to the one that's looked at by the Supreme Court in Friends of the Earth, for example.
Where do you draw the line between those which are mandatory for a rational decision and everything?
The way we would say it's drawn is you look at that in the context of the statutory scheme. My lord may have in mind the point made by the judge to say, well, where do you stop? Where's the limit? This is not practical. We say that's where our arguments dovetail together, because this statutory scheme interposes an examining authority or a person or group performing the function of examining authority who do that exercise of examining the materials. And they draw together and they interrogate, to go back to the interrogate inquisitorial kind of language, the material and present it to the Secretary of State for his or her consideration.
And if they decide that it's not necessary and it's not mandatory, what's the touchstone?
You could have a case, of
I've
course.
probably been very stupid, but I just don't understand this.
You could have a case, of course, in which somebody comes along, not this case, and says the examining authority's report was just too thin, didn't convey the necessary points. And I recognise the tension in my lord's question, the tension in the point my lord's making, because it may be that what we're actually describing is that the statute implies a wider class of things which are obviously material. And that includes, and I'll show you how this works in a second.
Including those that are decided not to be obviously material.
Well, and I recognise, of course, my lord's point is entirely right. Depends how you approach the question of obviously material. But if one comes, for example, to a consultation case, and we'll come in due course to a couple of examples of consultation evaluations of this, including a case called Stevenson, where Mr Justice Dove, with some insight, we would say, looked at how you move from obviously material to considering consultation responses. And there will clearly potentially be points which people make in consultation responses, which are, they may turn out to be bad points, or there may be points, had they not been made in a consultation, nobody would say, well, the decision maker needed to know that point. But because they've been made in a consultation, the court says, well, those are points that the decision maker needed to know as consultation points. And I'll come in due course to decision by Lord Justice Lindblom and Lord Justice Lewis.
I'm probably diverting you on this.
No, it's a difficult point, my lord. It's a difficult point.
On a different question, I understand that you accepted that in terms of the decision to grant the application for a DCO, that could be the Secretary of State or it could be a civil servant, but here it was in fact the Secretary of State. If we're dealing with a different decision, the Secretary of State may decide what is important and relevant. Is it not also the case that that decision, is it sufficiently important and relevant, is one that could be taken by a civil servant rather than the Secretary of State? There's nothing requiring the Secretary of State personally to take that threshold decision, is there?
If I've understood my lord's question correctly, we would say that you could have a decision in which the Secretary of State says, right, I'm delegating the whole of this DCO to an official, and then an official deals with all of the various elements of it. But given that this is all feeding into a decision by the minister...
Yes, but this is a different question. I understand that. But there are aspects of the decision-making process along the way to whether or not I'm going to grant it. My question is, why is does the decision under section 1042D have to be taken by the minister rather than by an official in accordance with the Cartona principle?
Well, we would say it has to be taken by the decision maker, the ultimate decision maker. So if the ultimate decision maker is an official, in other words, an official is deciding the DCO, then they too can do the 1042D exercise, which is decide what's important and relevant for that purpose of that decision. What we say you can't do is to split those up and in effect have a decision maker here, the Secretary of State, who is deciding on the basis of an exercise which has filtered out too much, if I can put it compendiously.
But why has he filtered out too much? Why must it be the same person that takes each discrete decision at each stage? Well,
because then you have the problem that we see in, for example, the National Association case, of the proposition that a decision on a DCO, a minister, as a matter of logic of that line of argument, could be taken by a minister who knew nothing.
No, that's not my question. The question is this particular fact important and relevant? And the decision has to be taken on that. And the question is, does that have to be the minister who takes that decision or the official? If it can be the official, and if he decides it's relevant and important, then the Secretary of State will have to look at it if he's going to take the ultimate decision. But if he said, no, decisions as to relevance and importance will be decided by the officials, and they decide, in fact, it's not relevant and important, that's the end of that bit of the decision-making process, isn't it? Or
my lord, I mean, we don't see any delegation of that kind here. We don't see any.
Well, it's not delegation; it's Cartona.
Well, my understanding of Cartona is in effect a delegation proposition. It's permissible to allow civil servants to do certain things, and we say it's not permissible in this instance to split up that exercise to the extreme. The minister who's making the decision, we say, has to be equipped with the information to do the 1042D exercise, which includes implicitly having the opportunity to look at and decide not to take into account things which, on analysis, he decides are not important or not relevant. And that sits alongside, and they interact, what we say about consultation. Because whether one uses the word consultation in the Moseley sense or not, and I'll show you in a second, I'm about to come to it, the documents which set up this process, the statement of matters and following, it was gathering of information, including propositions from objectors and then back and forth, in a situation where people were told the minister will take into account your consultation responses, and we say, even if that hadn't been said, that would necessarily follow. So whether you call it Moseley consultation or whether you call it a process which carries the same qualities, we say again, like the cases on consultation, the decision maker needs to know the essence, the key points of what consultees, or respondents, whatever you want to call them, have said in response. They may turn out to be bad points. There may be points that the decision maker doesn't want to agree with. But they can't simply leave that all to officials.
When you do that, and when you take us to the documents in your report, do please start, if you don't mind, with Rule 20, so I can remind myself what Rule 20 says before I read the documents that are talking about Rule 20. But all of that can go together when you get to that stage of your argument.
Lord, I said I also wanted to look at the sections dealing with what happened here, which, in the witness statement, page 163. That tells us that in this particular instance, paragraph 23, invited representations on various things. Come to that document in a second, you can see the contemporary documents. And then at paragraph 24, that simply summarises the to and fro, and the court's got the contemporary documents, and I'll show you those briefly in a second. And then paragraph 26, we're told that officials in the team consider those representations. Then to go to the point my Lord asked me about, Rule 20 just to introduce then what happened here. It's page 134 in the authorities bundle.
134.
Procedure following quashing. Where a decision of the Secretary of State in respect to an application is quashed in proceeding for any court, the Secretary of State to A shall send to all interested parties a written statement of the matters with respect to which further representations in writing are invited for the purpose of the Secretary of State's further consideration of the application, shall give all interested parties the opportunity of making representations in writing to the Secretary of State in respect to those matters. And whatever that sets up, it is not exhaustive.
It's not necessarily exhaustive.
Not necessarily exhaustive.
Could be.
It could be. But I'm not going to argue my Lord choice of language. That the point is the court still has a role and has to decide through the prism of fairness what more, if anything, needs to be implied into the process. Appeal bundle 44, page 1845 of the bundle. The same decision appears to be saw before.
Sorry, which page I was making a note?
It's tab 44
Of the supplementary.
appeal bundle, I'm sorry. Oh, sorry, authorities bundle. I'm sorry.
Oh, right.
Paragraph 171. First, it's been well established for many years that procedural rules such as the 2010 rules are generally not exhaustive of the requirements of procedural fairness or other public law requirements. Then over the page 172, Rule 20 imposes minimum requirements, should not be misread as laying down an exclusionary rule in relation to any additional steps that might be required in order to satisfy duty to act fairly in any particular case.
Could you just give me the page reference?
It's 1845 to 1846.
Thank you.
Paragraph 171 through 174 is the whole section.
Yeah.
And just in terms of whether controversy or the lack of controversy in that,
So it's very difficult. These are just abstract paragraphs. I haven't really understood what they were actually addressed at. I mean, the proposition that where necessary, it may be appropriate to supplement statutory provisions is well known. And I'm just trying to work out what the context is, because this is under a heading called addendum to the court's order, and the facts are pretty important in every case.
We don't ask the court to go any further than what my Lord said is well established, and we simply say that applies, and it's not a matter of dispute as far as I know, in the context of Rule 20 and this statutory framework. I don't think there's any great controversy in that.
And is this DCO or is this the planning rules?
DCO.
This is DCO, is it? Yeah.
And that's why you get to Rule 20, that's why the judge is talking about Rule 20. It was in terms of, it was a relief, it was a discussion about relief in a case where the judge had quashed the DCO.
Yes, I mean the key point there seems to be that these are not exclusionary requirements. Is that right?
And that's all we take from it, my Lord. I don't over-claim from that. And in the present case, I don't think there's any dispute about that. And indeed, the Minister, just for the court's reference, perhaps we could turn it up, but I need to come back to it later. Page 615 in the core bundle within the decision letter.
Do you want us to look at that now?
Please do, since it uses the same language.
Do you want us to keep Pierce?
No, I'm done with Pierce, thank you very much.
All right.
Paragraph 89 in the decision letter. Following the further consultations of, the Secretary of State is satisfied that interested parties have been provided with adequate opportunity to scrutinise all relevant documents and make their views known on this matter both during and since the examination. Further, in response to the suggestion that the examination should be reopened to consider this matter, or indeed any other matters, the Secretary of State notes there is no express legislative provision that allows the reopening of the examination, but acknowledges that the legislation imposes minimum procedural requirements and does not include any exclusionary rule in relation to any additional steps that might be required in order to satisfy the duty to act fairly in a particular case. It is therefore considered whether the examination should be reopened, because it's not necessary to do so for the reasons given above.
You're not arguing for reopening of the examination,
Exactly
you're
right.
arguing for the appointment of something like an independent expert.
And that is part of our complaint, as you will come to, in relation to the way the Secretary of State or the Minister deals with this, because we do say, there's two steps to this submission, we do say fairness required it.
When you say it's better to be exact, fairness required the appointment of an independent expert or the appointment of an expert.
Of an inquisitorial process, or process is inquisitorial in nature,
Yeah.
under the auspices of people with expertise that enables them to conduct the inquisitorial process.
Yeah.
We say fairness required it, but even if it wasn't required as a matter of law, as we see, the Secretary of State, the Minister, rightly accepted that he had a discretion to do so. And we say that discretion, if it was simply a discretion, was exercised unlawfully. I'll come to this in due course. In part because the Minister misunderstood what was being asked for. Exactly the point my Lord just put to me. And that was in part because he wasn't informed of what we were asking for. Well, can I put that decision letter down for a moment and also put down bundle 2, where we were looking at Mr Gilmore. Sorry, bundle 3, where we were looking at Mr Gilmore, and go to bundle 2. Bundle 2, where we see the process that we've just been discussing in the contemporary documents. Start, if I may, at page, supplementary bundle 2, page 3.
Yeah.
This was the statutory statement of matters. Paragraph 2, I'm writing in accordance with Rule 22 to set out the matters on which the Secretary of State invites representations for the purpose of his redetermination. That's consistent with Regulation 20. First bullet, these matters are any updates interested parties consider to be material to the information relating to alternatives considered by the examining authority in section 5.4 of their report, including, but I would add, but not limited to, I'll show you why I say that, the relative merits of longer tunnel options. and any other further information the interested parties consider to be material for the Secretary of State to take into account in his redetermination of the application relating to the relative merits of alternatives to the development.
What page are you on?
I'm sorry, my lord.
What page are you on?
I'm sorry, I'm on page 3 in bundle 2, SB2.
Yeah, thank you.
The bullet point at the foot of supplementary bundle 2, page 3. I'll unpack that a little bit in a moment, if I may, because it's very important in terms of the scope of what was being contemplated. There's then, on page 4, other matters on which updates are requested, including, for example, carbon budgets and so on. And then, fourth bullet on page 4, any other matters arising since 12th of November 2020 which interested parties consider are material for the Secretary of State to take into account in his redetermination of the application. Widely cast. Then there's a heading, the redetermination process, which at this stage contemplates one round of exchanges. Actually, as you'll see in a second, it becomes a bit of a to and fro. And then paragraph number 4, the Secretary of State intends to take into account in redetermining the application any relevant responses received to this round of consultation and any subsequent consultation. So it's recognising there might be a further consultation, which there is, and says the Secretary of State will take into account responses received. So whilst the word consultation may be being used not narrowly in the Moseley sense, that is the essential quality of this process. It is gathering information in the nature of consultation responses which the Secretary of State or the Minister will take into account. I said I would unpack the bullet point on the foot of page 3 in relation to alternatives. I need to unpack it in 2 ways, if I may. The reference there, and this is important, is back to alternatives considered by the examining authority as section 5.4 of their report. You have that. If I can ask you to temporarily put that bundle to one side and go to supplementary bundle 1. You have an extract from the examining authority's report. If I can go, please, to page 11, supplementary bundle 1. This is section 5.4, alternatives, to which the statement of matters referred, and it was inviting and making relevant to the Secretary of State's decision, second time round, the alternatives considered by the examining authority in this section of their report. And the headline point is that that included a range of options, including, let me just give you the headlines, longer tunnel options, because as the court will have seen, the concern here of the archaeologists is not the tunnelling necessarily as such, it's the shortness of the tunnel, so longer tunnel options.
Well, it's particularly the portals, isn't it, and the cutting.
Exactly.
Which break the surface amidst features of archaeological
within the World Heritage Site, exactly
within
right.
World
So if there were a longer tunnel that started and ended outside the World Heritage Site and was sufficiently deep and so on, it would, in that sense, bypass the...
I mean, this has long been the centrepiece of the debate at Stonehenge, this question, hasn't it?
Yes. So longer tunnel options is my headline as a type of alternative.
Which is not to say it's the only question when I say that.
No.
It has been, I think it's fair to describe it as the centrepiece of the debate.
We then get on to other routes, so routes which don't go through the World Heritage Site, which go round it, of which the example expressly mentioned by the examining authority in the report, page 12 of that bundle, route F10, and there are others in this evaluation.
That's the southern bypass route.
Exactly. You get F10 mentioned there, and again, F10 is mentioned on page 16, and there are other routes discussed. Picking it up, if I may, then at page 19, you see there, Stonehenge Alliance is mentioned in paragraph 5.4.51, putting down a marker in relation to alternative options. So first point I get from this is the breadth of the scope of the consideration of alternatives in the redetermination. It's not limited to longer tunnel options. It includes all of those that had been canvassed in this section here. Second point is this, and I'll show you how this fits within the judge's judgment first time round. 5.4.60 is the examining authority explaining the approach it is taking to alternatives. And they say this, and you'll see a bit more of this in the judgment in a moment. The only consideration of alternatives relevant to the examination of the proposed development are, first, under paragraph 4.27 of the NPSNN, to be satisfied that an option appraisal has taken place. And then there's a point about EIA and there's a point about compulsory acquisition. The point, which I'll develop further in a second, is that they were only concerning themselves with whether National Highways had done an options appraisal process. And you'll see in a second, they satisfy themselves that that had been done, because that is all that 4.27 of the NPSNN would have required. And in due course, the Secretary of State adopted the same approach. And that is one of the bases upon which Mr Justice Holgate quashed the decision first decision. Because he said they needed to go further. And I'll come to that in a second. And they needed to have looked, or at least the Minister needed to have looked, at the merits of alternatives. Just to finish it within this document, 5.4.71, insofar as the options appraisal is concerned, the XA is content that the applicant's approach to the consideration of alternatives is in accordance with the NPSNN. In other words, they have done an options appraisal and their approach is satisfactory. That is not the same as them having assessed the merits of alternatives. We'll see that in a second. We see that in Mr Justice Holgate's decision first time round quashing the first DCO, which you have in Authorities Bundle tab 47, page 1939 is the beginning of the judgment.
Sorry, I'm falling behind. We're looking at Stonehenge 1, are we?
Stonehenge 1.
And just the reference again then. Reference again, sorry.
So it's tab 47.
Yeah.
Starts at 1939. Relevant section, it starts at 1995. Para 244. It is important to see how the panel approached the issue of alternatives in section 5.1. 245, IP1's case, applying paragraphs of the NPSNN, was that the only consideration alternatives relevant to the examination were to be satisfied that an options appraisal has taken place.
What exactly is an options appraisal? What would that involve?
That involved explaining alternative schemes or alternative options for dealing with the identified problem, of the kind which the examining authority reported on in 5.4, which we looked at a moment ago. In other words, is this option preferable to a longer tunnel option, or a different route option, or a modal alternatives option? And the simple point is that the examining authority, and in due course the Secretary of State, and this is what the judge said, I'll show you this in a second, confined themselves to checking, as the MPSN on its own would say, whether such an exercise had been undertaken.
So somebody, I don't yet know who, will have conducted an appraisal of the various options, but the examining authority and the Secretary of State at the first round did not themselves do more than check that somebody, and you'll tell us who in a minute, had appraised the various options.
Exactly right.
So who was the person who appraised?
National Highways, the developer.
National Highways. So National Highways appraised the various options, including longer tunnels and the southern bypass. But all the examining authority and the Secretary of State did was check that they had appraised them.
Exactly right. And we see that, paragraph 256 and 257, Stonehenge 1, in his decision letter, the SST merely stated that the impacts of a number of factors, including alternatives, were neutral. In relation to alternatives, the SST relied on section 5.4 of the panel's report, said he saw no reason to disagree with the panel's reasoning and conclusion on these matters. Accordingly, and I think this is the answer to my Lord's question, both the panel and the SST considered alternatives as the same basis as IP1, in that it was necessary to consider alternatives, but only in relation to whether an options appraisal had been carried out. The judge then looks at the NPSNN and the paragraphs in question, 426 and 427, to see, in effect, whether they preclude more. And I can skip that over and go to the end of 276, if I may. Last sentence of 276. Was the SST entitled to go no further in substance than the approach set out in 4.27 of the NPSNN, PR 5.4.71? In other words, only look at whether an options appraisal had been conducted. In my judgment, the clear and firm answer to that question is no. The relevant circumstances of the present case are wholly exceptional. In this case, the relative merits of the alternative tunnel options compared to western cutting and portals were an obviously material consideration which the SST was required to assess. It was irrational not to do so. Not merely a relevant consideration the Secretary of State could choose whether or not to take into account. I reached this conclusion for a number of reasons, the cumulative effect of which I judge to be overwhelming, and he then sets those out. So that is really important in understanding and framing the exercise which the statement of matters is contemplating. Because not only are we concerned with all the alternatives considered in 5.4, we are also concerned, or at least the Minister should have been concerned, with their relative merits. And critically, this was not something on which the examining authority had opined. Because the examining authority thought that all it needed to do was look at the fact of an options appraisal, it hadn't evaluated for itself the options, providing a recommendation that the Secretary of State could adopt or not, nor had it reported through its report in a way that was intended to allow for that to happen. That wasn't their job as far as they were concerned. The point is they got it wrong in law. That's what Mr Justice Holgate held in Stonehenge 1.
Sorry, the second failure was that you say they hadn't assessed it for themselves, the options, and then they hadn't...
They therefore hadn't reported on them. They hadn't reported because they didn't think they needed to, because of the nature of the exercise they thought they were doing, on the merits of those options.
So now, at the redetermination stage, the Minister will have to do that.
Exactly.
And will have to consider representations as to the relevant merit. And did he do that?
Exactly right, exactly right. And he has to do that. Well, he does do that in the headline. The difficulty is the process by which he does it and the basis on which he does it. So we don't say he makes the same headline mistake again Our concern is the base on which he does it, and that's what I'm going to come to shortly.
Right, because that's quite important.
It doesn't repeat the same error.
No, but I'd be interested to know what error it is.
Well, I'll come to that, my lord. He still plainly has to reach a lawful decision on a lawful basis, and that's where we're going to come to. Put away Stonehenge number 1 for now, if I may, go back to supplementary bundle 2.
Right. Just for those working with paper, the clearing of the decks, I think.
Yep.
So
Try and do that. SB2, back to our statement of matters and the following process.
yeah.
So back in SB2, we saw the Regulation 20 trigger for that. I'm not going to take you, for now at least, to the National Highways response to that, because that response then led, you have this at SB2 page 6,
Yeah.
quite properly, necessarily indeed, to an invitation to all parties to comment on what National Highways had said. Well, let me just show you one thing that they had said which colours the subsequent process. In the same bundle, so without disturbing the desk, you have at SB2 page 151 part of their response. Which at 158 says this at 1.2.14. The applicant's position remains that the scheme would have a slight beneficial on the OUV of the WHS as a whole. Now that simple statement conveys a lot of nuance, because the examining authority had concluded significant harm. The Secretary of State first time round had disagreed, and indeed disagreed second time round, and said less than significant harm, but nonetheless harm. So going into this further process...
Is it less than significant or less than substantial?
Well, I'm sorry, my lord.
Is it less than significant or less than substantial? Because in
substantial, my lord. Sorry, my lord. My lord's right. My lord's less than substantial because it's still significant. Sorry, my lord's absolutely right.
No, I just wanted to be sure you weren't drawing a distinction.
I'm not drawing a distinction. Sorry, I'm just sloppy on my language.
Right, so the minister disagreed with the examining authority and said that it was less than substantial, and the examining authority said substantial then, had it not significant?
Yes, yes.
There was a disagreement on the degree of harm.
Yes, and that matters because if the minister had had agreed with National Highways and said this is beneficial, that would have been led you down a very different path in terms of the overall evaluation. So we then have...
Is it worth just picking up, I mean, when you can come to it when you like, but at some point just to look at what the policy says about that relation between...
My Lord, Ms Hutton can do that in due course,
yeah.
my Lord. Yes, we had quite a lot of debate about that the first time round, you can imagine, because it does take you down a different decision-making course in terms of how you then evaluate the heritage impacts.
Yes.
So in response to a great deal of things put in by National Highways, amongst others, the Stonehenge Alliance responded, and you have a number of documents from them in Supplementary Bundle 2. If I can pick it up first off, if I may, at page 186.
Presumably they've been making the same point in their representations to the examining authority, and presumably that's one of the factors at least that led the examining authority to agree that it was substantial, not less than substantial, So this has been canvassed, has it?
Well, insofar as it was about heritage harm, but I'm now going to look at other issues around, for example, the merits of alternatives.
Right. So the documents that you're showing us now are relevant because
the Secretary of State invited comments on alternatives within the scope of 5.4 and any other matters. And if I go to page 186, this is, I'm afraid the document is slightly out of order. This is, if you like, the covering document of a pack of things, of which you've got some. So we see at 187 that the Stonehenge Alliance put in submissions, paragraph 2, on a number of topics arising from the statement of matters trigger. And the rest of this document, or most of the rest of this document, is concerned with, as it says on the above paragraph 5, procedure. And I signposted this submission earlier. Paragraphs 9 and following, I'll show you the following in a second. The Stonehenge Alliance made the specific point that a different process was required. In the present case, the nature of the new evidence is such that it cannot be fairly examined other than through a fresh examination or by way of an inquiry. Given the nature and the scheme and severe impacts it will have, not least on the WHS as already found by the Secretary of State, it's imperative that all of the evidence is robustly tested by appropriately qualified experts. The ordinary examination procedure under the Planning Act provides for this.
Well, that sounds as if she's asking for a fresh examination, but you're not asking for that today.
No, she's asking, well, if they were, they're asking for more than they need to, but the critical point is the robust testing by appropriate experts, and they then explain the quality of that, or the nature of that rather. Paragraph 12, under the statutory scheme, the SOS decision is predicated upon receipt and consideration of a report by examining authority following the examination of the application. The statutory examination process involves an inquisitorial procedure through which the evidence of the applicant and others is robustly tested. They're not necessarily asking for an examination of exactly the kind.
Well, they are actually 13. Well, that's exactly what they're asking.
Whether or not they're going further than they need to, the core of what they are seeking is a process which is inquisitorial, appropriately qualified experts, and then paragraph 17.
Well, we'll have to read this, but if we think that it was a request for re-examination, that's one thing. You say they may have been asking for more than they needed to have asked for, but isn't it firstly a question of reading the document and deciding what it actually means to any reasonably informed observer? And we'll have to decide if they were asking for an examination, a formal examination, or whether they were asking for something like that or different.
Well, they can't have been asking for a formal examination in the statutory sense because there is no statutory formal examination at this stage. So it can only be of the kind, but the essential quality of what they're asking for is not, to go back to the point that we canvassed earlier on, oral hearings.
No, that's a separate side issue. We're talking about examination which is primarily written but conducted by particular people. Mm-hmm. But they can have oral hearings on specific issues.
Exactly right.
And I must say, I was reading this for myself, and you showed us that letter where the Secretary of State said he could reopen it if he wished. This seems to me, but I've got to read it all carefully, as they're asking for that, for it to be reopened, so that there will be an examination by an examining authority of the alternatives.
Well, what they are asking for, and it can't be a statutory re-examination because there is no such thing, is a process, the qualities of which they explain. And if it were to be said that, well, the minister didn't need to know about that or think about that because it was put in a particular language, we say that misses the point because the substance of what they're asking for, we say, is clear. And just to go back, as it were, to the...
Well, just to make it clear to me, you're asking for independent expert assessment, somebody outside the department, or is it just expert assessment, somebody who's familiar with...
Appropriately qualified experts is what is said in... There's obviously a discussion to be had about whether, and now's not the time to have it, whether the people who sit on examining authority panels are independent.
No, I'm not bothered about that. I'm bothered about a different thing. It's quite a simple question. I understand there is a call for expertise, and I know what expertise is, somebody who's familiar with these matters. It's a very specific question. Is it a call for independent expertise that is outside the department?
But it's a call for interrogation. Well, sorry, independent in the sense of outside the department. Yes, sorry, yes. Yes, I should listen to the
I've just written down, it's not a request for independent assessment, it is a request.
Independent of the department. Sorry, I overthought my Lord's question.
Simple questions, yes.
Critical point is testing by an expert who is independent of the department.
Yes.
Where do we see that where do we see that in here? I mean, I've seen the reference to the nature of the evidences cannot be fairly examined other than through a fresh examination or by way of an inquiry. And you've said, well, they may have been asking for too much there, but where in this document do they say the critical point, or what adds up to the critical point is testing by an expert independent of the department?
My submission, that's in the nature of what they're asking for. They're asking for a process which is akin to, and that starts the paragraph 9 process, fresh examination or by way of an inquiry. And
I
then
think someone's pulling your gun, but...
Paragraph 35 I'm helpfully drawn to. Foot of paragraph 35.
Yeah. Is that in our response to the Secretary of State's?
Page 198.
That's referring to another part of their suite of response documents, if that's...
And where... I think both my Lord and I are slightly unclear. When you say the critical point is testing by an expert independent of the department, if it's the critical point, we might hope to find it in the document, but at the moment, I'm not sure that...
It's the end of paragraph 35.
End of paragraph 35, it happens helpfully.
Thank you.
Drawn attention to.
Well, yes, these matters should be submitted to re-examination, capital E. That sounds awfully like they were contemplating an examination of the sort that's provided for at the earlier stage, and which hadn't happened because they decided not to look at alternatives just to check if there was an appraisal. And that's going to be re-examination under an inspector with a relevant expertise who may give independent expert advice to the Secretary of State. You've got to read the whole thing. That still seems to be tied to a re-examination process.
Well, they're referencing, and you see again in paragraph 25.
25.
Paragraph 25. The nature of the information mean either that...
Hold on, I haven't got paragraph 25 yet.
Sorry.
Yeah.
Fresh examiner, they're lay people.
Well, no, they were advised by Miss Hutchins. She's a very experienced barrister.
Suggesting a process, and they rightly recognise that they can't call for a statutory examination because there is no such thing. And they focus on the essence of that as being akin to an inquiry or an examination with interrogation.
Well, read 25, it looks, if you read the whole again, what it looks like is that they're saying at C the proposal should be refused, in which case there will be a fresh examination if they make a new application, or there should be what's now described as an extra statutory inquiry.
Or a fresh examination.
These
putting
three,
it there,
these three, I'm so sorry to interrupt, but just to try to draw this to a clear conclusion, there are three options put forward, as I understand it, in paragraph 25. They're prefaced with the word either. In fact, there are three options, not just two. but the linking word between B and C is or. So as I read that, these are the three options being canvassed. Is that right? Is
Yes.
that how we should read it? So it would
Yes.
be what, in any one of those three.
Yes, but they're not being used as labels in the abstract, and we're not concerned. The court's not concerned with, in my submission, the labels. For a question of fairness, one's concerned with the content of them. Call them what you like. The components of them, the core component is the inquisitorial stroke interrogation by experts to give independent expert advice, to pick up words at the end of paragraph 35.
And you say that could have been, but need not have been, what would in effect have been a reopening of the examination, or a further examination.
Yes. I mean, since it's non-statutory, it's what it is, isn't it?
Yes, but which goes back to our earlier exchange. Yes. So that's really what you submit.
Yes, yes. And I mean, we're helpfully, but it's jumping into JR Ground 1, we say that fairness required that, and I'll elaborate that in due course. But even if fairness didn't require it as a matter of law, that the minister needed to be appraised of our consultation response, even if we want to put it in those terms, on a proper basis. The Alliance also put in, and I won't take you to the detail of them at least for now, because they put in further responses in due course, submissions on alternatives, and other matters. I'll come to those compendiously in due course, if I may.
They made a positive case, did they, saying that none of them would work, or one of them would be the best, or...
Sorry, none of what sort of work? Alternatives?
Yes.
Yeah, well, I'll show you in due course what
Right.
they said about F10, for example. If that's where my lord's question. So we then get, and I don't...
You said they put in submissions on alternatives, and I just wondered, to try and short-circuit it, what those submissions were. If it was none of them would work, or there would be one that would work in particular, the southern boundary or longer portals, it would have been helpful to have known that. But if you want to take us to it at a later stage, that's fine. I'll try and remember that we asked.
I'll take you to it in due course, if I may. I won't take you in the time available to the to and fro that then took place, because entirely consistent with what had been set out, the minister, officials at this stage, invited each side to comment on the others. But the critical thing in each case is that what they were doing, and all that they were doing, was inviting comment on what the other party had put in. So, for example, page 10, SB2, page 10.
Page 10 of what?
SB2.
Thank you.
National Highways was invited to comment, this is SB2 page 10 number 1, on a representation by a group called the Consortium of Stonehenge Experts. And that representation the court has at SB3 page 3 and following. And at para 6.6 on SB3, page 5, started earlier. The section starts 6.1. I should start with a heading. Page 4 on tab 3, bundle 3. Remains of a large Beaker period settlement with burials. And then section 6 of this document deals with that. And at 6.4, they say, at no stage in the assessment process was there recognition by National Highways of this substantial heritage asset. At 6.6, this asset can be considered as a national and even international significance.
I'm really sorry, which page are you on?
Bundle 3, page 5.
Thank you.
So not recognised 6.4, national even international significance, paragraph 6.7, meets the criteria for designation as a scheduled ancient monument. So expert submission making those points, right or wrong, bundle 2, page 10, National Highways is simply asked this, asked to confirm whether these assets have been included in the assessment, and if so, to specify in the material where the assessment of those assets is set out. If an assessment has not been undertaken, provide the necessary assessment so the Secretary of State can appropriately consider them.
And what's wrong with that?
Nothing wrong with that
Right.
as an initial question. The difficulty is twofold. First of all, there is no interrogation of the information that is provided. All that is being done is to ask for where we find your assessment of it, and there is no...
They're asking where the assessment has been done so they can see what the assessment says. Or if it's not been done to provide an assessment, it's not saying here any more than that.
No,
is it?
absolutely,
We need
that's
to
why
look at a
we
lot
don't
more than that.
And we don't complain about that as an initial question. Please provide us the information.
Yeah.
What is then missing is two things. The first step is any interrogation of that assessment by the officials.
Anywhere else in the bundle, they never went back to it again.
Exactly right.
Right.
Until we get to the decision letter.
Yeah.
And the relevant paragraph in the decision letter is paragraph 96 on page 616 in the core bundle.
Presumably, somebody came back and told the Secretary of State either where in the assessment they were dealt with, or alternatively provided new assessments. So that happened, did it?
Well, when you say the Secretary of State, back to officials, yes.
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 So something was said in response to this. You can find the information here.
Yes.
Right. And then
But
we've
there
got
was
paragraph
no...
96 decision letter. Yeah.
So most of that paragraph is dealing with the process. Last 5 or so lines of paragraph 96. At paragraph 1.2.9, the applicant states that the assessment of the significance of these issues and the likely impact from proposed developments are set out in the environmental statement, etc. And then it's the last sentence. The Secretary of State is content that these assets have been appropriately considered by the applicant. Now, all that the Minister knew about any of this was that paragraph and that sentence. So a conclusion is stated, is written on the paper, as if from the Minister. no evaluation by the Secretary of State. Well, on that process of without interrogation,
I'm just not following this because I've got a whole long paragraph before I get to the end sentence that sets out all the various documents that the applicant say they considered that. So there's been a toing and froing and a consideration of what they've said. And then there's the one line that the Secretary of State's content that those assets have been appropriately
the simple point
considered.
here is there has been no interrogation of any of that by officials or by the Secretary of, sorry, the Minister. Particularly, my Lord, in relation to the specific point that had been made by the consortium about this being tantamount to a scheduled ancient monument. They make a specific point which would have been a policy game changer, which is simply not conveyed there or evaluated because the Secretary of State doesn't have the consortium's document. When my Lord rightly refers...
Hold on a moment. They don't address the claim that it is equivalent to
a scheduled ancient monument. So my Lord is right, sorry, of course my Lord is right, in the earlier passages on that page, on that paragraph, I'm sorry, there is reference to provisions within the environmental statement, some of which we accept the Minister can be taken to have looked at. And I'll show you why we say that in a moment. But he doesn't see the consortium's representation and its specific proposition, for example, that these could be taken to be akin to a scheduled ancient monument. He is simply given and adopts the compendious conclusion at the foot of 96 about appropriately considered. But he does that, sorry to emphasise the point, without understanding the representation to which it refers. So there are 2 points, and at each stage of this we get 2 points emerging. One is in relation to the absence of interrogation.
Well, you keep saying that, but I mean, somebody has considered this. I mean, somebody's gone through 96 and has reached a conclusion, and that's their recommendation, in effect, to the Minister, and he agrees with it. So there's interrogation by the officials, or are you saying, no, they never looked at it at all?
Not in that, well, that in our submission, that's not what we mean by interrogation.
Right, well then you need to explain to me, because I haven't fully understood, when you say no interrogation, which seems critical, what that actually means in the context of this case.
Well,
Who's
to take
to do
that
what?
example, just to illustrate, to speculate on a piece of interrogation would be, it's being said this is a scheduled ancient monument. What have you got to say about that? Why do you say that the consortium of Stonehenge experts are incorrect, for example? So, my Lord, you
say no interrogation. It seems to be a slightly different point. What you're saying is that there's a failure to consider a specific recommendation or representation by the consortium that it should be treated as if it were equivalent to a scheduled ancient monument, even though it wasn't one. So it wouldn't matter who did the interrogation. You're saying that submission hasn't been addressed.
just to illustrate the point, it may or may not.
Have I understood it correctly?
My Lord, yes, it may help the courts understand.
just
See
didn't write that down.
examples of the kinds of things.
No, hold on, let me just make a note. The suspicion is no one has considered whether or not it should be treated as if equivalent to an ancient monument.
Can I perhaps illustrate the point this way, and it may or may not be helpful, is in Supplementary Bundle 1, you have, the court has at least answers to questions from which you can see the kinds of questions that were asked in an interrogation process. So page 259,
How many?
259 and following in SB1.
This is about alternatives again.
It is, my Lord, but I'm simply illustrating the kinds of questions that an examining authority, by way of interrogation, was asking on that topic.
As I've understood at the moment, this topic that we're talking about, which is the 4 assets identified by the consortium, we were told that there'd been no interrogation. When we go through this, clearly there has been consideration that the assets that are referred to have been looked at by the applicant in certain documents. So that process has occurred. You've then taken us to a submission that it was equivalent to a scheduled ancient monument. That's what
that was the proposition being made.
And you said there's no interrogation of that, and I've written down that the submission is that no one considered if it should be treated as equivalent to a scheduled ancient monument.
My Lord, yes. Can I? It may help, may not help, to illustrate what we mean by interrogation when we look at page 259.
Well, I think of it as who has to ask what. So
it's the independent person who is conducting the exercise has to probe, and I'll show you where the guidance. Perhaps I should show you now. Either. If you look in the appeal bundle, tab 50, sorry, authorities bundle, tab 59, page 2487, I mean that, I think I do mean that. Yeah, so this is guidance for the examination of applications for development consent. That's at 2485. Paragraph 64. The duty of the examining authority is not simply to accept the statement of common ground or to react to the evidence presented. The role of the examining authority is to ensure that all aspects of any given matter are explored thoroughly, especially with regard to the matter's fundamental decision. So their role is, and that's in the nature of examination, the statutory word, and the recognition of this being an inquisitorial process, is more proactive than simply collecting what each side says and then evaluating it. And then there is the further step of what the minister is told, which is a separate and discrete step in the process. I won't take more time on the to and fro of that process because it gathers, as you will have seen, somewhere close to 2,000 documents of representations in addition to what's already there. I'll pick it up, if I may, in the briefing to the Minister, which starts at page 17 in Supplementary Bundle 2. And what we have here First of all is the covering email, and then the documents that are provided with that email and subsequent emails. I'm sorry, it's page 17 on Supplementary Bundle 2. So the email says this: please find attached a submission that seeks a decision on, etc. And over the page, you see under the heading List of Annexes what is being provided to the Minister for the purpose of this decision. And the annexes are this: A, Annex A, and I'll show you this in a second, links to the application documents. B, decision letter, draft decision letter. C, table showing impact on cultural heritage assets. D, examining authorities report, but of course that only deals with the materials up to the prior to the redetermination. E, habitats regulation assessment. And 4, summary of interested parties' responses to mission report and applicants' responses to it. So those are the annexes to the submission that we then see starting page 19. Paragraphs 4 to 6, they're quite a helpful summary of how we've got here.
Well, 2 is important. Improve the development consent order for the scheme for the reasons set out in the decision letter.
Exactly.
So the inspector's got to read that, and if he agrees with the reasons, he'll approve it, and if he doesn't agree with the reasons, he won't approve it. But he's going to take that into account as part of the process.
Absolutely, my lord, absolutely. But the question is whether what's in the draft decision letter provides him with a basis.
It's sufficient, yes.
It's sufficient. And we'll come to that in a little while. Page 19, paragraphs 4 to 6. The examining authority recommended consent should be withheld because the adverse impacts, especially the substantial harm to the significance of the World Heritage Site designated asset, but also other harms, including public rights of way, etc., would strongly outweigh the benefits. The Secretary of State's original decision considered that any harm to heritage assets was less than substantial and that this harm, along with other harms, was outweighed by the benefits, so he granted consent. Following an application for judicial review, the High Court quashed the order on the basis of the decision of not taking into account the impacts on all the heritage assets and had failed to take into account potential alternatives. It's a slightly, had taken into account potential alternatives, but only in the sense of had there been an options appraisal, but the court's,
but it's clear what it means.
Seen that. Considerations. Having reviewed all relevant information, see Annex A for more information about the application documents, including the responses to consultations received during the redetermination period. It is considered that you should grant consent. In other words, just to unpack that slightly, officials had looked at those materials, including responses to consultations, and recommended the granting of consent. Now, that in itself is unproblematic, depending upon what more information the Minister has given for that purpose. And what you then have in the rest of this paragraph at the top of 20 is more information and more pointers in the documents to the heritage assessment. So 5 or 6 lines down it says this: the impacts on all of the affected heritage assets and the tables from the environmental statement dealing with the impacts of these assets has been reviewed and are attached in Annex C. So we'll see that in a second. So there's an additional briefing in Annex C. While some assets are greatly affected and great weight should be given to harm-affected assets, it's considered that overall the harm is less than substantial and that the benefits of the proposed development are outweigh these and all other impacts. The decision letter at Annex B sets out the full consideration of the case of proposed development and weighs all the benefits and adverse impacts. That's the point my Lord was putting to me. The decision letter sets these all out and weighs them all. So that is fundamentally, the decision letter was the base on which the Secretary of State, the Minister, was fundamentally being asked to make the decision, along with some supplementary materials dealing with particularly heritage assets. Reference Annex B and Annex C. And in addition to that, if you go back to the list of annexes on page 18, summary of interested parties' responses to the missions report and the applicants' responses to it. And we'll see some further documents in a second. So additional material was given to the Minister in relation to the heritage aspects. And he was directed to the annexes dealing with heritage aspects. And we accept that he can be taken to have known about and taken into account those things because they were drawn to his attention. He was asked to read them for the purposes of the decision. The question, though, is what more he didn't take into account, other than as set out in the decision letter. And that matters in particular, but not exclusively, when we come to look at alternatives. In terms of the annexes,
Well, there is a paragraph on alternatives. Are you going to deal with that or come back to it?
I'm sorry, say again, my lord.
There is a paragraph specifically on alternatives in the submission. Are you going to deal with that or come back to it?
Paragraph 9.
Yes.
Paragraph 9 says this: 6 alternatives to the proposed development were considered, including one of which would extend the board tunnel and one of which would extend the tunnel to a cut and cover section. However, it's considered that while these alternatives would avoid some, but not all, of the less than substantial harm to heritage right of proposed development, it's considered that all the alternatives give rise to other or additional significant adverse effects. In particular, the 2 tunnel alternative options are significantly more costly and will take longer to implement, leading to a delay in realising economic, transport and heritage benefits. It's considered that the benefits of the alternatives over the development proposals in heritage terms are not such as to outweigh these adverse effects. Now, it's not clear whether that last sentence is intended to refer to all alternatives or only the alternatives that were mentioned previously, the longer tunnel alternatives, but it's not telling the minister anything about anything other than the longer tunnel alternatives, whatever it says about them. And again, it is reporting to him the outcome of evaluations by officials. It's not providing him with the basis on which he can do the evaluation that he needs to do of the alternatives. See Mr Justice Holgate in Stonehenge 1. He is being told about the evaluation done by officials and their recommendation on the basis of that evaluation. We then have Annex A, links to the application documents and the environmental statement. And what that does is it provides the minister with hypertext links to a number of things. First off, all matters concerning the application documents for the A303 Stonehenge project can be found on the Planning Inspectorate's page for the scheme here. That is a link to the entirety of the examination library online. All the documents from the original application are published there, together with the responses to the consultation that have taken place during the redetermination process. And then some specific examples are highlighted, drawn to his attention. Of particular note is the environmental statement. This sets out the applicant's assessment of the impact of the proposed development. The full environmental statement with all the annexes can be found at the library of the scheme here. Then there's a reference to the cultural heritage section and within the environmental statement to chapter 6. And then the next paragraph, there's a reference within the environmental statement to chapter 14. And then there's a reference to the technical summary. And the simple proposition is that the minister cannot be taken to have followed all of those links to read all of those documents. Many thousands of documents.
Which ones do you say he should have followed?
He's not being told to follow any of them, actually.
No, that's a different question.
I'm sorry, my lord.
That's a different question.
He needed information.
To a different question.
He needed information. He needed information, for example, on what consultees, I'll use that word, has said about alternatives, for him to make an evaluation. Now, that information is buried, not buried, sorry, that's a pejorative word, is in the examination library. He could have found that information if he had wanted to in those documents. We completely accept that. But in order to do so, and you've got witness statements and a statement of common ground on this point, he couldn't follow that link at the top there and type in, for example, F10 alternative or consortium of Stonehenge experts, Beaker settlement or whatever. All that he could have found, if he'd done that, the search engine allowed him to identify the title of a document and the maker of the document. We say he needed to be provided with the material to reach the conclusions which he reached. And in a way, this is not an answer to that, that's the whole point. This set of links is not, he's providing him with the potential to do that, but he can't be taken to have done it. And that's our appeal ground one. There is authority. There are two authorities, which I'll show you briefly, which pick up on that question. What assumptions can be made about web links? And we say the simple point, and I'll make this good in due course, is that you can't assume that the minister tracked down and read every document which he could have got through the web link. The law, and I think the Court of Appeal has said this in a case called Hunt, which I'll show you in due course, is that a decision maker can be taken to have read the documents provided to them for the purposes of a decision. So we accept, for example, that the minister read the draft decision letter and read the heritage assessment that I've just referred to and read the sections of environmental statement, which I'm about to show you at least the covering emails for, but isn't to be taken to have read documents which they might have found if they'd wanted to via a web link, unless the instruction, explicitly or by implication, told them that they needed to do so for the purpose of the decision. And here...
Perhaps we should look at Hunt, should we?
We can look at Hunt, my lord.
Well, sorry, do you want to finish the submission and then take us?
I could do, perhaps, perhaps if I could just finish this trail of documents, that might make more sense, and then I will look at that. I just want to look at the totality of the decision documents. So that's Annex A.
And just to be clear, in response to the question my lord asked, so I've got it clear in my mind. This is to do with the documents received from interested parties following the statement of matters on the question of the alternatives to the proposed transport.
For example.
Well, hold on.
Yes.
Let me write that down first and then pause for a moment, please. That's what I've understood the submission to be all about. Not an, for example, but that's what it's about. The things he should have looked at and specifically had his attention directed towards were those comments by people who were interested parties post the November start of the process again on alternatives.
Well, Lord, yes, but that's not the end. The including is critical, and I'll come in. May I come to that in due course?
Well, we will need to know.
I will show you, my lord, in due course. You can be reassured. I will show you. The moment I'm trying to provide the framework and give you some indicators of where the points arise. It is alternatives by way of an illustration to illustrate the point for the moment. I'll come back to the other points in due course. You then have page 22. 23, sorry, all still in supplementary bundle 2. Further emails. So 22 is the covering email with the A to Fs that you've just seen. And then 23, 24 and so on provide as attachments, because the attachments were too big to put on a single email, that's what we're told, extracts from an environmental statement dealing with heritage assets. So the Minister's attention is drawn to the documentation provided by National Highways on heritage asset effects. And one understands why the officials were concerned to do that, because that was one of the grounds on which Mr Justice Holgate had quashed the decision first time round, was a failure to consider the heritage impacts on each of the individual components. So they take care to provide the Minister this time round with the information that would allow him to reach that conclusion. And you'll see in a second, he says, I've considered the annexes, and we absolutely accept that he can be taken to have read the material in those attachments to those emails.
So there's no complaint about the way in which heritage assets were dealt with?
In relation to his awareness of the information in those environmental statement documents, absolutely not. Because those are things, go back to the Hunt rubric, which we'll come to in due course, that were provided to him for the purpose of the decision.
So he's okay on assets, he's not okay on alternatives, yeah?
Not heritage in its entirety, I'm sorry, but those documents. So he's not provided with the Consortium of Stonehenge Experts or the materials from the Stonehenge Alliance.
No.
Those would have had to have been documents which he would have needed to extract by following the links. And we say he can't be taken to have followed the links in relation to those documents. So we accept that he's to be taken to have read, look at page 25, for example, Annex C2, Table 1.1 to 1.7, Appendix 6.8, the environmental statement, for example.
But not the consortium report.
Exactly.
And that results in illegality. Yep. Yep.
You then have the same bundle, the approval documents, and I just want to show you this because it completes the trail. If you start at page 320, you've got an email reading backwards. Button 319 running on to 320 is the email that you saw a moment ago providing the Minister with the materials, inviting him to make a decision.
This is in the same bundle.
It's in the same bundle.
Yeah.
Bundle 2, page 18 to 20 is the whole document.
Yeah.
Then on 319, the answer to that, after the Minister's done his deliberating, hi Gareth, many thanks for this submission. Thank you as well for your patience. Minister Merriman.
Just pause a moment, I'm so sorry, it's my fault entirely, but I'm hearing the references, but I'm reading there's something else. We're in Supplementary Bundle, Volume 1, page 9.
No, bundle 2.
It's tab 16.
Right. Right, that's great. Tab 16. Thank you very much. Yep.
2/3 of the way down the page. Hi Gareth, many thanks for this submission. Thank you as well for your patience. Minister Merriman has reviewed. He agrees the issue for the DCO. He agrees to issue the DCO for the reasons set out in Annex B. That's the draft decision letter. Minister Merriman confirms he considered all the annexes in order to reach his decision. Now, that is express recognition by him that he's considered, as we say, the annexes. And that's why that we would have accepted that as a matter of presumption anyway, but he puts it beyond doubt. He's considered the annexes. So that is the heritage table assessment provided in Annex H, those extracts from the environmental statement that was provided with those covering emails and so on. But he's not saying, and I followed the links to look up what, for example, the Consortium of Stonehenge Experts said, or Stonehenge Alliance said, or whatever it may be. And just pausing for a second here. If the examining authority in the examination had indeed looked at the merits of the alternatives and provided information to the Secretary of State with that in mind, that would at least have provided him with the information base in relation to the evidence that it was at that point in time. But they hadn't, because they didn't think they needed to do that exercise. So we didn't have the benefit of the process of drawing together and summarising responses and reaching recommendations on the basis of them, even in relation to the earlier period, let alone anything new that might have been said in the redetermination.
You say that's the context in which this needs to be viewed.
Exactly right. And therein lies the part of the difficulty. At the heart of our concern here, in relation to the grounds around information to the Secretary of State and the process that led to it. They interact, inevitably they interact, because the absence of a further interrogation process and the absence of materials to the Secretary of State through that process or in some other way meant that when he came to approve paragraphs of the draft decision in relation to alternatives, for example, which I'll look at in a moment, all he had was what was in the draft decision letter, which presented him with officials from conclusions from officials, and their explanation of their recommendation as far as it went, but not any of the underlying material or anything else that would allow him to make a properly informed decision. And I'll come to show you how that works in due course, but that's just a signpost of where we're going. So there is then a pause, just still on page 318 to 319, there's a pause because one of the issues related to the approach that had been taken to the cumulative assessment of carbon, where there was a judicial review in relation to another DCO scheme, that meant there was a pause in the deliberation on this one, pending the High Court's decision on that one. That judicial review failed, which is what we see referred in 318, 319. You don't need to worry about the detail of that. We've now received the judgment on the A47 cases, that's top of 319. So then the Minister comes back to it, top of 318. That's just to explain the two-stage process. Thank you for the update, top of 318. HM Hugh Merriman has said that his original approval stands with this update and you can publish tomorrow. But that then is the decision, but nothing's changed in terms of the issues caught in that intervening period. And you then have the decision letter. So can I then pick up the point my Lord Justice Lindblom asked me about a moment ago, which is Hunt and the Links cases, because this is our appeal ground one. And this goes to the extent to which the judge relied on the Minister's knowledge of documents that he could only have got through the links. Let me summarise it that way. So if I can put aside that supplementary one for a moment and go to the two cases, the first of which is Hunt. You have this in Authority Bundle, page 24.
First one.
It's at page 921, the start of the decision. And we do need to look at this with a little bit of small steps, I'm afraid.
I thought it's not reported, is it?
I can't answer that on the fly, my Lord. I suspect it is, but...
We haven't got a head note.
So, my Lord, you see, just to pick up the background, paragraph 2, it was an appeal against a decision dismissing a judicial review in relation to a budget decision by the local authority. And at paragraph 4, you see that one of the issues, and this is the end of paragraph 4, was the failure to discharge section 149 of the Equality Act, the public sector equality duty. And just to signpost where we're going, the issue that the Court of Appeal had to grapple with was the committee's knowledge, or assumed knowledge, or not, of the equality impact assessment. Now, what we see at paragraph 32 is the description of the EIA, Equality Impact Assessment. What we see at 46, on page 936.
So you wanted us to be conscious of 32?
32 simply because it's giving you it introduces the Equality Impact Assessment, which is a document.
And then you went to where?
46. So the issue that the Court of Appeal was concerned with was the committee's assumed knowledge of that document. Paragraph 46, by a letter of the 13th of February 2012, each council member was summoned to a meeting with the full council on 21st of February. An agenda was included. Members were reminded by item 14 on the agenda that they had received all the agenda papers supplied to the Executive Committee and that they were commended to review them prior to the council meeting. It is not in dispute that each member must be assumed to have respected that commendation and to have read all the agenda papers provided to them. Those papers included an officer's report recommending approval of the resolutions, and such report listed various background papers provided to members, one of which was the MTFP, Appendix 6 of which included the summary of the EIAs. Not the EIAs, but a summary. They were also provided with the officer's report to the Executive Committee, of which paragraph 12, the quality implications read, all major proposals have been considered for any equality implications, and a summary of this process and its outcome, together with any specific implications, are reported within Appendix 6. The sense of that can be read as meaning that members did not need to look beyond Appendix 6 in order to understand the equality implications. And we say, if we need to, the same is the case here when it told the minister, briefing paper, told the minister that all the considerations were set out in the draft decision letter. If anything, we don't need to go this far. That was giving him an indication he didn't need to read further. Here, minister, is the briefing material. Read this, and he indeed, as we fully accept, read it. Paragraph 46. Then we go to 78 in the report. Heading above 78, did the council discharge the PSED? 79, the judge found that council members had read the relevant EIA and that their consideration of it enabled them properly to discharge the PSED. Now, what we're coming to in a moment is the Court of Appeal disagreeing with the judge's conclusion that they had read the EIA. Recognising as it did...
Attention, please. Attention, please. This is the Incident Control Officer. The emergency condition has been resolved.
Oh.
The building is declared safe. All personnel may return to normal duties.
That's nice.
All key emergency staff, please report to the main hall for debriefing. Attention, please. Attention, please. This is the Incident Control Officer. The emergency condition has been resolved. The building is declared safe. All personnel may return to normal duties. All key emergency staff, please report to the main hall for debriefing.
I'm not sure to be whether reassured it's safe or reassured that I didn't know it was dangerous anyway.
I think I should apologise. I'm very sorry you were interrupted.
No, my lord. The simple point was that the members needed to have read the EIA to discharge the PSED. The judge concluded that they had, and the Court of Appeal is about to disagree. 82. The judge's finding of fact as the members' consideration of the EIAs themselves was a secondary finding based on the evidence of an exclusively written nature. We have before us the same material in principle, etc. We take a different view. For our part, this is 83, and again with respect, we are unable to agree with the judge that the inference that he drew was one that was available to him on the evidence. We have no difficulty, nor was the contrary suggested, in accepting that if council members are provided with a particular set of materials for the purpose of the meeting, they can, absent positive information to the contrary effect, be taken to have read all such materials and also have read any such additional materials to which they were expressly referred and to which they were told they needed to have regard for the purpose of the meeting. If, for example, they'd been told a key document was too bulky or expensive to copy and circulate, but was available at a given website address, and that they were further told in appropriate terms the documents required reading for the purpose of the meeting, we consider they must be taken to have accessed and read it. In the present case, however, we do not interpret the language of Appendix 6 as indicating to council members any need or requirement to read the EIAs themselves. Whilst they were told how to access the EIAs, they were not told, either expressly or impliedly, they must or should consider them before the meeting. They were in fact summarised in Appendix 6. The fact they were summarised in Appendix 6 itself suggests a reference to documents themselves are not essential. Why bother to summarise a document which must be read in full? Then there's a specific point there.
Would you like us just to read down to the...
Read to the end of the side lighting. I've read the main bit, but carry on if you...
Would that help you? Yep. Yes, we'll do that. Thank you.
So we then have in tab 50 of the authorities bundle, Mr Justice Holgate, a case called Suffolk Energy Action Solutions. It's tab 50, page 2080, at the beginning of the document. Paragraph 3. So this case went to appeal, but not on this, didn't deal with this point. Court of Appeal didn't need to deal with it in the end. Paragraph 3. The central issue in this case is whether the Secretary of State acted unlawfully in dealing with a complaint by the complainant. So the issue, which we're going to come to in a second, is the Secretary of State. Did the Secretary of State read, or can he be taken to have read the complaint? The complaint is picked up, mentioned, paragraph 90 on page 2103.
2103.
2103 in that bundle. That explains the complaint. We then get at 131 on 2112.
Hang on, I'm trying to note this.
The heading is the Secretary of State's decision.
I just have a look at 1991 to see what the complaint was, so one understands the facts.
Of course.
So something's been promised to them, and in return they wouldn't make any objection.
Well, my submission is not concerned with the content of their complaint.
No, but I want to understand it.
So their complaint was that the developer was operating a process of through the compulsory acquisition regime, which, so they said, required landowners to sign up to what they call the non-disclosure agreements, which they said were distorting the planning process.
Right, so was it that they signed up to agreements and as a result they couldn't make representation?
That was the substance of the complaint.
That what they'd agreed to interfered with the process of the planning complaint.
And that does then pick into that. We need to look at that, which I don't think we do. That would go into the Court of Appeal's decision, which looked at that very question. For the moment, all I'm concerned with is the much more limited question of the Secretary of State's awareness, therefore engagement with the substance of the complaint. Doesn't matter what the complaint was about. Paragraph 136, there were two decision letters because of the two developments, and there's a quote in 136 on the issue. After dealing with land and rights, the land and rights to be required, the justification for the power sought, statutory undertakings, funding and outstanding objections, the decision letter considered the use of non-disclosure agreements. And then the quote, this issue has been cited by the examining authority, but the examining authority provides no detail in its report. And then these are the references to the complaints. A submission was made to the Secretary of State by the claimant on the 30th of November, setting out detailed concerns. The applicant responded to these concerns. Now, what you don't have in the judgment version of it is that each of those references had a footnote which provided a hypertext link to the particular document in question. And then over the page 26.32, the Secretary of State has considered the representations of both Sayes and the applicant carefully due to the important issues that they raise about the conduct of the examination and the rights of all the parties to have a fair hearing. So the question was, could the Secretary of State be taken to have followed the links and read the complaint and the response to it? The judge picks that up at paragraph 1.142. Mr Wolfe submitted there was no evidence the Secretary of State considered for himself the representations made by Sayes in its complaint regarding the agreements. But para 26.30 of the draft decision letter before the Secretary of State expressly drew his attention to the submission, which included representations and was said to set out detailed concerns. It was also referred to the IP's response. Links were provided to both documents. Paragraph 26.3.2 said that the draft decision letter said the Secretary of State had carefully considered those representations due to the important issues they raised. And then at 143, the judge picks up the decision in Hunt, which you've seen. And then at 144, assuming, without deciding, that the same approach applies to decision-making by a minister with assistance from officials, I consider that the presumption in Hunt that materials were read by the decision-maker applies in the present case. There's nothing to rebut that presumption. Not only was the Secretary of State given links to the document, he was also given a draft decision letter in which it was said that he had considered the material carefully because of the important issues it raised about the rights of landowners to a fair hearing. In para 26.34, the Secretary of State was effectively being asked to endorse the conclusion there had been no interference with the right to a fair hearing. There were sufficiently clear indications the Secretary of State he was required to read the material. There's no legal basis for the court to infer that he did not. So that was a very specific situation.
Well, paragraph 145, in these circumstances, it is unnecessary for the court to consider the legal principles where a minister relies upon a summary by the officials of materials they have appraised. That seems to suggest there may be a different principle.
That's a different point. We'll come to that. I'll come back to the summary point in due course. But for a moment, just on the...
Oh, I see, okay.
Just my recollection of the appeal in that case, this wasn't a point on appeal, was it?
It wasn't a point on appeal because, well, at least it wasn't a point that the court dealt with on appeal because the court, in effect, went straight in and dealt with the substance of the concerns about the non-disclosure agreements, if they were called.
That's right.
And so it didn't need to. So basically, it held there was nothing in it, nothing in the complaint.
I was just trying to recall what we had to decide in that case. Well, we didn't have to decide.
You didn't have to decide this point, no, and didn't decide this point. So in the situation where the draft decision letter specifically referred to the two documents and gave individual links to the two documents, and where the Secretary of State in that case said that, literally used the words, and the judge italicises it, considered the material carefully, the court drew the presumption that the Minister, the Secretary of State, had indeed followed the links to those two documents and read them.
If in the reference I've got at SB 2319, where he says he's considered the annexes and you accepted that, if he'd said I've considered the annexes and their contents, would we be having this submission?
Well, it's basically what you mean by "and their contents," because there's all the difference in the world between considering, for example, the draft decision letter, which is a document he can be taken to have read, and consideration of a document which provides you with links to thousands of other documents. And it's an altogether different proposition to say he's read the decision letter, which is given to him as an attachment.
He didn't say that. He said he'd read the annexes.
Well, considered the annexes.
Considered the annexes. And I'm just wondering how far a secretary, what we're really arguing about here, whether if he'd said, I've considered the annexes and the materials lying behind them, would we be having this?
Oh, that's a different. But he didn't say that.
But that you would, if he had said that,
If
we're on that limited point.
Well, limited, except that what turns on it is thousands of documents.
Well, I appreciate that. I appreciate that.
And in one sense, I mean, I have on many occasions been rightly pushed back by the court for saying this decision maker doesn't need to read every single document in a response to consultations or whatever, and nobody would argue that the Secretary of State needed to read.
That's one of the reasons why I raised this question now.
Yes.
Because it seems, speaking entirely for myself and probably not understanding the nuances properly, it seems to me that this is intimately tied up with your submission about how the need to read everything for the minister.
Of course. It is absolutely intimately tied up with that, and that's exactly where I'm going to go next.
Well, don't let me stop you.
No. My Lord, the simple point is the minister can't be taken in our submission to have followed the links to, for example, read the response from the consortium of Stonehenge experts or the Stonehenge Alliance representations on alternatives or on inquisitorial process, the materials I showed the court earlier in the morning. And of course there's a question about whether he needed to know about those things, and that's exactly where I'm coming to in a moment. When one then looks, just to complete this little trail of materials, at the decision letter, page 598 in core bundle 1,
Sorry, that reference once more.
page 598, core bundle 1.
Thank you.
paragraph 18 is to deal with that. That's one more thing before George German. Paragraph 18 says this: the Secretary of State has considered the applicant's response to the statement of matters and all other responses of interested parties to the statement of matters. Now, we say that can't be taken to mean that he followed the link and read every single one of those documents.
Why not? Why not?
We say that's a presumption too far.
It's not a presumption, it's an inference from what he says.
Well, we say...
Unless you challenge what he says, which is he has considered the applicant's response to the statement and all other responses by interested parties, unless you're challenging the truth of that, why doesn't it cover...
It depends what one means in that sense, by considered. I'm not challenging the truth of it, it's just a question of what it means. The Secretary of State has agreed to a draft decision letter which includes that sentence, that paragraph, I'm sorry. In agreeing to that, and this is not to challenge the truth of what he's agreed to, we don't accept that he can be taken to be saying, I have followed the links to read every single one of those 1,800 documents, thousands and thousands of pages on the website, which I would have needed to get through a link on the website, and I would have needed to follow a search engine which only allowed me to search on the title of a document.
Well, I may be asking this in a very inappropriate way, in which case forgive me for straying to areas which I should know better. But does that mean that the fate of this DCO depends upon what is meant by considered?
I
think the answer is yes.
Well, in one sense, if the court, it's not the totality of the case,
No.
but I accept that if the court were to conclude that the minister had indeed read, not just been aware of the existence of, behind the draft decision letter and read all the documents but that he could have got through the links, then I accept that a chunk of our case would fall away. But it's a really important, and as a mission, it's a really important point of really elementary public law and how judicial review approaches decisions and how decisions are taken. If that sentence were written, just to put a slightly different characterisation on it, if that sentence were written in the context of the Secretary of State having received an examining authority's report, which is more conventionally the situation you would have, not in a post-quashing situation, then the Secretary of State would have done the consideration, including therefore the consideration of the consultation responses, with the benefit of the filtering and the advising of the the examining authority. And that's exactly what an examining authority does. They summarise, this party says this party says that, there's this material, we've evaluated, here's our recommendation. And reading an examining authority's report in the completely conventional way, which is what a DCO letter like this is normally referring to, and saying in that draft, I have considered, embraces considering the examining authority's report on the point. But when we come to, without wishing to re-emphasise, alternatives and post-Stonehenge 1 elements, that can't be the case here.
That makes me wonder whether this really isn't a case about the way in which decisions are taken in central government departments. I think if accepted, you couldn't expect the minister to have read the thousands of pages of representations that come in. You do insist that the minister must read some things, and we know two of the things you'd like them to have read, the consortium report and the alliance documents on transport alternatives. But I wonder whether this isn't the royal we, the Secretary of State's consideration, that in fact when you're dealing with central government, what you get is the officials look at it, and although it's called a draft decision letter, that's the technique. What it is a set of recommendations with reasons as to what they think should happen. If he agrees with it and turns it into a decision letter, then it'll be the decision letter. If he doesn't agree with it, he'll go back and say, no, I'm sorry, I don't agree with that. So I do wonder whether we've started with, you said earlier on, oh, no, the Secretary of State here, he could have let a civil servant deal with it, but he hasn't, and therefore he must do it himself. I do wonder whether it is a more complex decision-making process where a lot of the analysis is done by the officials, and they say what is the result of that process, and what you need to do is show why some of the decision letter doesn't adequately deal with the issues that were raised, which is a much more conventional challenge.
And that's where we'll come to in due course, my Lord. Be reassured. I hope we'll get to that point. My Lord, it is really fundamental, but it's not. And I make 2 points. I think if I can trespass half a moment. First of all, this is an unusual situation because it's a redetermination following a quashing, and it's also, and this is why I emphasise the points I made about the Planning Act framework. It's within a very specific statutory regime, which sets up, and I won't go back to the 104 consideration, some very specific statutory issues that have to be addressed by the decision maker. And this is where our two grounds interact, because the minister's ignorance, and I don't mean that in a pejorative sense, unawareness of some of these things, was in part a consequence of the fact there hadn't been a further inquisitorial leading to a report type process. All there had been is the draft decision letter. And in the first round of DCOs, that's not what any minister would have. In the statutory scheme, the minister always has the examining authority's report. Lord, is that a convenient moment?
Yes, indeed. We'll start again at 2 o'clock, and I'll just repeat what I said at the outset. We're going to stop today at 4 o'clock. Good. Or 2 o'clock.
4 branches.